Welcome to Frank Wealth Insights, a financial and investment podcast from Return on Life Wealth Partners. They look at your money. We look at your life at returnonlifewealth.com.
Happy holidays. This is Frank Fantozzi, and welcome to the latest episode of Frank Wealth Insights podcast. I am your host, Frank Fantozzi. On today's episode, I will be discussing estate planning, or what I refer to as your legacy planning, as this is your legacy. So why don't people get excited about estate planning? Well, who wants to talk about their own demise? Maybe if we reframe and look at this process as leaving your legacy to those who matter most, it might be a little easier to get jump-started and to talk about something that's very important. I also feel that the complexity coming from the unknown and all the jargon, wills, powers of attorney, living will, revocable trust, charitable trust, executor, trustees, beneficiaries, and maybe I need to worry about taxes too. No wonder people keep taking this important planning opportunity and just kicking it down the road. So let me help take some pressure off. So unless you make what they call an irrevocable election, which is basically a decision that you can't change, which are really far and few between in this process, you can make changes to your plan as often as you want. So one of the things I want you to kind of get over is that once you create a estate plan, it's not permanent. It is permanent if you don't make changes to it, but you can get something in writing, and if you change your mind or feel differently down the road, you can make changes as often as you want. Typically, I get asked, how often should I really review and put together my estate plan? Well, if you have an estate plan in place, I would say a typical cadence is probably about every 5 years, just to make sure that as you change and grow up and go through different phases of life, that your feelings about what you have written in your documents still represent how you feel about the people that you've named in the document and how you really want things to work out. But otherwise, I would say if there are any life events like becoming an adult and you have some assets as a good starting point for a reason to get a will in the first place or put together some estate planning documents, the birth of a child, a death of a family member, a new job, you move to a different state, changes in the status with people named in your documents are usually common reasons to review the document and possibly update the document to make sure, again, that they are in line with how you're feeling today. So another way I also help people with the estate planning process, or as I like to say, legacy planning, because it is your legacy, is people look at this as like this huge universe of thought process. And my job as an advisor is to kind of get you to be able to focus in on really what the process is. And the way I like to look at it and the way I share it with clients, especially if they can articulate it in a flow chart or in words, is basically taking what you own, giving it to whom you want, when you want, with any conditions. So let's look at some of the subparts there. First of all, you can only give what you own. So it starts there. I think that's kind of common sense, but sometimes people, kind of have struggled with that part of it. Just like, okay, these are things that you own. This is what you can really dictate where they go. So that takes us to part two. Whom do you want to receive these assets? And normally those are people that really matter to you. Family, friends, maybe a favorite pet, a charity, a school. The next component is when you want. Now people think, wow, this is my death documents, my estate plan. So it's really when I die that everyone receives anything. And in legacy planning, again, I like to refrain how people look at this because you have an estate of assets that you own. You don't have to wait to your demise or when you expire to give your assets away. So legacy planning could be making gifts during your lifetime. The benefit of giving assets away during your lifetime is the joy that you receive back of this experience when you see those people react to your gift, the gift of gratitude, the impact that you make in their lives or at the school that you donate to or the charity that you care so much about. So, legacy planning is not just leaving assets to whom you want upon death, but also to those people while you're alive. So, it's really a lot like giving a Christmas gift or a birthday gift to someone and then just to see the reaction on their face. So, donating and giving while you're alive is an important part of estate planning. And then the last component is with any conditions. Now, I will start with we always counsel people to give with a warm hand versus a cold hand. See, a lot of people want to control their assets from the grave. So it's really not a true gift. And that's not what we're really looking for here. But common conditions where you might want to put some control on or some conditions is, for example, when you leave assets to minors. Okay, how are those assets going to be cared for for that minor's behalf? Another is while you're legally an adult at 18, inheriting a large sum of assets, between 18 and 30, you really are not filled with a lot of life experiences, and receiving a lot of money too early, you might make decisions that potentially could squander what you've worked hard to help those people that you're leaving assets to squander that unnecessarily. So, for example, your parents, you both pass away, you leave assets in a trust, and you put some conditions like my child can receive 1/3 of the assets, the principal at 25, and another third at 30, and another third at 35. And during that time frame, the trustee, who we'll talk about a little bit later, has the power to provide health and maintenance to that child if they're going to grad school or going to start a business or buy a house and they need more money sooner. Certainly the trustee will be willing to represent your family, your interests towards that child. But the whole idea is, in this example, by the time the child's 35, they should have enough life experiences that giving them all the assets at that time would make sense. However, an extreme example is trying to control those assets until that child is well into their 60s. You can see, controlling from the grave becomes a little excessive. So now let's talk about some terminology that'll help start to pull this all together for you. Let's define some of the terminology so that it doesn't seem as foreign and or frustrating when you start to hear these terms, because you have an idea of what they mean and the role these terms play in your legacy planning. So a common term you hear is your estate. Well, your estate is really everything you own outright. That is your estate. It has a total and it's composed of various assets. It could be a house, a car, an investment account, your 401k plan at work. That is your estate. The next term is your probate estate, and it does differ than your full estate. A probate estate is basically a subset. It is your assets that do not pass by a beneficiary designation, i.e. by law or by trust. These assets will have to go through probate, which is a legal process to ensure that your assets get to the right people, either by the terms of your will, or if you don't, states basically have a hierarchy that if you die without a will, that your assets just don't go to the government. I know that's a common myth, but every state has a hierarchy. So say you don't have a will and you have a spouse, then all your assets are going to go to the spouse. If you don't have a spouse but you have children, it'll go to the children. If you don't have a spouse or children, it'll go to your parents, and so on and so forth. So it basically goes through your family tree, starting with the most important person, which will be your spouse, then your children. So even dying without a will, your assets will get eventually distributed to people that are most likely in your family. Now, our goal is that you don't want to not have a will or potentially a trust. You really want to dictate the direction of your assets. Now, if you want to avoid probate, which, again, probate has a function. It has a function to ensure that your assets go to the people that are closest to you by bloodline. That's basically the simplest way to look at it. Now, you can avoid probate. Now, a lot of people think you need a trust. However, by simply putting beneficiary designations on assets, you'll avoid probate because it goes by operation of law. You've already stated that when I die, this asset goes to this person. So, common agreements or assets that you could own that normally require you to fill out a beneficiary designation is a life insurance contract or an IRA or your 401k plan. Now, if you have a bank account, you're not forced to put a beneficiary designation on, but you can. So we suggest to people on your investment accounts, your bank accounts, even your house, that you put a beneficiary designation. And in some states, like the state of Ohio, you now can put a beneficiary designation on a car that you own outright. So you can avoid probate very easily by making sure that every asset that you own has a legal beneficiary designation attached to it. Now, many states have a de minimis amount, or what they call an expedited probate process, if your estate value is below certain dollar levels. So I would reference you to look at each state law and see if there is a de minimis amount and if there is an expedited probate, because this is a state-by-state process. So let's talk about some of the most common estate planning documents that will probably cover 99% of Americans. First of all, you have these powers of attorney. A power of attorney, you could have one for someone to make financial decisions, and we'll talk about what that looks like and what a power of attorney actually really does. And there's also one for medical decisions. We also talked about having a will, which is a very common document. In the will, it'll handle, think of it like a catch basin. Anything that doesn't go by trust or by beneficiary designation will go by will. In the terms of the will, say who will receive your assets. In addition, if you have minor children, you'll specify a person to be a guardian. That is a person that you will elect to take care of your children as minors, and any provisions that you provide to that guardian. Now, we do recommend that you talk to the people that are important in your life, that you feel that I'm going to entrust my children with you, because they might love your children dearly, but they might not be in a position to want to care for your children. So it's something that you want to get their blessing ahead of time so that you can make sure that they are okay with being guardians of your children. Now, there are also things where some people say, well, geez, they're great people to raise my children, but they're terrible with money. You can also create a trust where someone is helping manage the money to assist in money-making decisions so that the money is protected and will be used appropriately for the care of your children. So other key people, and we're going to define some of these roles that will be determined in your will, is who's the executor or executrix. That is a person, executor is male, executrix is female. This is a person that really handles the probate estate and the wishes that are in your will. Lastly, you could create what they call a revocable trust. And as the name implies, revocable, you can terminate the trust, you can change the terms of the trust, which is very, very important. If you feel differently 3 to 4 years from now, you can change the terminology of that trust. You can change the beneficiaries, just like you can in your will. You can change the assets that go into that trust or that are owned by the trust. Now, keep in mind, any assets owned by the trust are only for legal reasons only. It does not change the tax properties of those assets. So if you put an investment account in a trust, you as the individual are usually the trustee of your own trust, and then you'll pick us what they call a secondary or tertiary trustee in case you're incapacitated or have passed. But these assets, whatever the tax ramifications, really pass to you as the owner of the assets. So it really all shows up on your individual tax return in your 1040. Trusts also offer better protection than a will. It keeps your affairs private. So one matter that people don't really realize is anything that goes through probate becomes public record. So one of the famous, and I'm dating myself because he's a famous actor, has been gone for a while, John Wayne, he died without a will, and all of his assets went through probate, and you can find out anything you want by going to Orange County courthouse and pulling up the records to his estate and find out what went on with John Wayne. So those are really the common documents. You have a will and powers of attorney. You may choose to feel that you could benefit from a revocable trust. Again, it doesn't change the tax outcome from you. It also doesn't protect you against creditors. However, it does make the management of the assets that are owned by the trust a little easier. So let's talk about some of the key players that we've defined here. So we talk about a power of attorney. So if you have executed a durable power of attorney, whether for medical reasons or for financial reasons, and we're going to use that as our focus here, then you've signed a document appointing a person to make financial decisions on your behalf. This document is called a power of attorney, and the person named to make decisions on your behalf is called an attorney in fact, otherwise known as an agent. If being precise is more important to you than being understood, use the phrase attorney in fact at your next social gathering. Not only will people not understand you, but they will most likely find you a little bit obnoxious. So using the correct name is less important than understanding the limits of an attorney in fact's power. The person you name as an attorney in fact is charged as your fiduciary with making financial decisions using the highest standard of good faith, fair dealing, and undivided loyalty in making decisions in your best interest, in keeping your goals and wishes in mind at all times. Your attorney in fact's power, however, is limited in three ways. First, an attorney in fact is only permitted to act while you are alive. When you have passed away, the attorney in fact loses all power. Second, an attorney in fact only has control over those assets not held in a trust, as trust assets are governed by the trustee. And third, you are appointing certain powers to the attorney in fact, so you can limit what the attorney in fact can make decisions for you regarding certain financial decisions as well as medical decisions. Next, the executor. Now, whoever's the executor or the executrix of your estate, and usually, again, if you're married, you're probably going to name your spouse as the executor or the executrix, or you can name an attorney, but understand that an executor is not an easy job. I mean, you're basically entrusted to kind of clean up your estate because you're gone and there's a lot of work to be done. Now, an executor or an executrix can be paid. Obviously, if it's a spouse, usually that doesn't happen, but if you usually hire a third party, there's usually a compensation schedule that is preset by the courts to pay that individual, or you can choose to pay more if you choose. An executor is named in your will to shepherd your probate assets through probate court process and ultimately to your beneficiaries upon your death. Probate assets, to make things even more complicated, are those assets in your name alone as opposed to being held jointly in a trust or, as I shared with you earlier, an account that utilizes designated beneficiaries. Where the attorney in fact's power stops, the executive power starts. In other words, the executor has power only upon your death over your probate assets only. Lastly, the trustee. So, if you have a trust, you have named a trustee to manage, invest, and distribute the assets in your trust. Unlike an attorney in fact whose powers are limited to the period of time you are alive, or an executor whose powers are limited to the period of time after you die, your trustee can serve both during your lifetime and after your death. A trustee's powers, however, are limited to those assets held in the trust. A trustee has no power over assets outside of the trust and whose powers are outlined in the trust agreement, which is what you ask the attorney to draft on your behalf. So you have full say-so on what you're going to allow that trustee to do. So to review, an attorney in fact versus successor trustee during your lifetime is when you become incapacitated, the authority granted to your attorney in fact will be activated under your power of attorney for either medical decisions or financial decisions, and the power granted to your successor trustee will be activated in your trust. The scope of their respective decision-making authority really depends on the extent to which you have funded your trust. Your trustee has exclusive jurisdiction and control over the assets in your trust, and your attorney, in fact, has jurisdiction, subject to any limiting terms in the power of attorney over everything else. If you have a trust and have funded it with all your assets, your attorney, in fact, is going to thank you for making his or her life relatively easy. Now, the executor versus successor trustee after your death. Upon your death, your attorney, in fact's power ceases, and your executor's power, assuming he or she is appointed by the probate court, commences. Your executor, however, only has power over those assets not in trust, not held jointly, or not in account with beneficiary designations. Accordingly, the executor role may be limited. If you have a trust and funded it with most of your assets during your lifetime, your successor trustee will have comparatively more power than your executor. The last document, which I believe is very important for people to consider, is what they call a living will. It's not to be confused with your other will. A living will be a legal document that states the type and level of medical care you want to receive if you are unable to make decisions or communicate your wishes. It's also known as the Advanced Healthcare Directive, Advanced Directive, or Medical Directive. So lastly, you heard me earlier talk that there's a 1% of America that gets treated a little different because they have more complexity. And I just want to touch on this briefly because we really don't have time in this segment of our podcast to go into this area. So for those people that are extremely wealthy, and I'm going to define that based on how the government defines it from a gift and estate tax purpose, is that the federal government has a lifetime gift and estate tax exemption amount, which for 2024 will increase to $13.61 million per person, or $27.22 million per married couple. There's also, because it's a combined table, a federal gift tax exclusion, which will increase to $18,000 per person in 24, or $36,000 per married couple. So the reason why that's important is if your net worth is greater than those amounts, either as an individual or a married couple, you could pay estate taxes. And so that just creates a whole new ballpark because most people don't want to pay estate taxes. They're tired of already paying income taxes. And to add insult to injury, if you're very successful, now the government wants to tax your wealth before you can give it to the people you want. So there's just a whole new realm of tools, various irrevocable trusts, charitable trusts, spendthrift trust, revocable living trusts, unit trusts, generation skipping trusts, life insurance trusts. There's just a whole quiver filled with arrows to enable your financial advisor and your attorney to help figure out how to get under these thresholds so that you can take advantage of your exemption. So basically, if you're not over this $27.22 million as a married couple, you will not pay an estate tax, which is great. But as soon as you start to go over that limit, you will pay 40 cents on the dollar. So for many people, they want to take proactive measures on how to do that, and we'll save that for another podcast. But I just wanted to make you aware that, again, for 99% of America, having your powers of attorney, a will, possibly the use of a revocable trust, and we do highly recommend having an advanced health care directive, are really the nuts and bolts of what you will need. The clear thing, and again, to make this process easy for you, is to go back and think about it in two ways. One, it's your legacy. It's your opportunity to impact the people that matter most to you or the organizations that matter most to you during your lifetime if you choose, as well as when you expire at your demise. And the way I would suggest you really look at it is if you can articulate, whether in a flow chart or in words, that I'm going to take what I have, give it to whom I want, when I want, with any possible conditions. As long as you can articulate that, your financial advisory team and your legal team will be able to help construct documents that will represent your best wishes, knowing that as long as you don't make any irrevocable elections, you can change this at any time. And that we recommend you every 5 years, unless you have a life event like the birth of a child, getting married, a change in status of anyone that's in your document, would require you to really revisit that at that time. We would say every 5 years, take a look at your documents. Does it really represent how you still feel? If you did, dust it off, put it back in the file, and revisit it in the future. So with that, we hope you feel a lot more comfortable about estate planning, or what we call legacy planning. I do want to thank all of our listeners who took the time to join us today. If you found this information helpful, please take a moment to subscribe, like it, share it, and on future podcasts, we will talk about more items that could be relevant to your financial well-being. If you want to learn more about how Return on Life Wealth Partners can help you pursue your important life goals, please give us a call at 440-740-0130 or visit us online at returnonlifewealth.com. Thank you.
This has been Frank Wealth Insights, the financial and investment podcast from Return on Life Wealth Partners. Your life, your money, your way. Experience financial planning the way it should be, not the way they want it. See how at returnonlifewealth.com. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. This communication expresses the views and opinions of the participants as of the date it was recorded or indicated, and such views are subject to change without notice. This podcast is being made available for educational purposes only and should not be confused for any other purpose. The information contained herein does not constitute and should not be construed as an offering of advisory services or an offer to sell or solicitation to buy any securities or related financial instruments in any jurisdiction. This podcast may discuss forward-looking statements that are based on then-current beliefs of the participants. Investment advice offered through Planned Financial Services, a registered investment advisor.